The state wrote a 12-page brief to win a fight the defense isn't really having. They argue over and over that negligence is not bad faith and that McCain had no sinister motive. Fine. But the defense's strongest path does not require any bad faith at all. And the bad faith test the state is using is not actually the test the Supreme Court wrote. So the question for tonight is not, was McCain a villain? It is, what did McCain know? And does the state even have to lose on intent to lose this motion? We think the answer is no. The state can lose without any villain at all. Let's get into it. Good evening, beautiful humans. Welcome to Defense Diaries. I'm your host, Bob Motta. And as always, I'm joined by my beautiful and brilliant co-host, Allie. What's up, girl?
Hey, babe. Hey, all.
What you looking at over there? What's going on?
I thought I heard a knock, which usually only happens like in the afternoons when your dad's waking up. So I was like, what am I hearing?
The old afternoon wake-ups. Yes, yes. So we're going to get into it. The state filed their response today to the defense's brief that we went over. I think, what did you say? It was May 22nd. I think we handled it the evening that it hit, right?
Yeah.
So that thing dropped today. I hit Tracy up. I'm like, can you pull this? She pulled it within seconds. And of course, that could be found at the Seeking Justice Discord page as well. That's a fabulous channel. It's where you can get all of your legal filing needs fulfilled. And if you're so inclined, throw a dono at him, because Tracy does some really hard work over there. And I know her cohorts are doing hard work as well. So, and they would appreciate that.
Right. So let's just say, like, to before we start reading, like, to get into this a little bit. So the facts here are about as charged as they get. A father, a daughter he believed was being abused by a man out on bond, a chase in the dark, a shooting. But the motion is not about whether the shooting was justified. It's about a dash camera inside a dead man's truck that was recording that law enforcement took and then disappeared with no paper trail for over a year. The fight is what happens to a homicide case when the state loses the one neutral recording of the encounter.
Sounds like you almost did a second cold open.
I don't know. Maybe I did.
Is that what, did you try to one up my cold open?
I think so.
I feel like that's exactly what you just tried to do.
All right. So in Arkansas, once Spencer raised self-defense, the burden doesn't sit on him to prove it. The state has to disprove it beyond a reasonable doubt. So Arkansas law on, justification, and that's basically the whole ball game. So as it sits, like, with this structure, the state carries the burden to disprove self-defense, and the state is the side that lost the only objective, neutral recording that could have carried that burden. They did not lose the defendant's evidence. In effect, they lost their own, although the defense wants to use it. And the Arkansas Supreme Court has already been in this case, as most of you know, and it sided with the defense. I think, was that May of 2025 where the court threw out the gag order?
Well, it was the Supreme Court, Arkansas Supreme Court tossed the gag order. So that sounds about right. Right.
And the court there called it a clear abuse of discretion. As you guys know, we do not have that same judge, as things progressed. But there's sort of two kind of buckets here, and the state is only focusing on one of those buckets. You've got road one, which would be like a Brady, and then there's some I think they cite to Trombetta, at least they did in the defense, case law, that Supreme Court case law, when the evidence has apparent exculpatory value before it vanished and there's no comparable replacement. If the defense proves that, the state's, you know, the state's mindset doesn't matter at all. That's
Yeah.
it, you know? And that's what the state just like literally ignores the whole time. The whole 10 to 12 pages you talked about in the cold opening, fighting a fight the defense isn't fighting. They're
Yeah.
just focused on bad faith. And then that's the second part is under Youngblood, if the evidence was potentially useful and the police acted in bad faith. And that requires, you know, the test of knowledge. Now, the case they talk about, you know, requires it to be like with malice, but that's not really all it says. And they try to frame the state as like, oh, this is just an inadvertent negligence. No, 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 no. Sorry, that's not what this is. This goes so far beyond that because there's no police reports on it. There's no, you know, this is concealment. They were concealing that it even existed until they couldn't any longer. So things to keep out for, like as we
It
read
was
the
worse than that. They concealed it until they let slip an email from McCain to the AG's office. That's how it came to be known. But you know, it was inadvertent. Like obviously that email from internally from the Lonoke County, you know, Sheriff's Department to the AG's office was not supposed to go to the defense. Slipped through the cracks. They became aware of it. And then, of course, they had to do their mea culpa. You know, I mean, it doesn't surprise me. They're leaning into the, you know, kind of the bad faith thing. It's the easier thing for them to defend because it's really hard for defense attorneys to be able to come up with the evidence to prove bad faith. So that doesn't shock me. Does it shock you that that's the way they'd approach it?
No, it doesn't. But I think that you can reach this whole sinister purpose, um, and not mere negligence when it goes like to gross negligence, to recklessness, like we have here,
Yeah.
tied with what you're talking about there, like an entire, oh, I watched it, I didn't report it. I, you know, like nothing anywhere. Turn off your body cam. I mean, all of those things. But the state's trying to frame this as all about whether there was like a sinister intent and whether the state has proved that. So when we when the facts themselves are what kind of can prove that here. But when we read this, like listen to every time, does the state ever tell us what McCain knew about the camera or only what like his intentions were? So count how often they talk basically about his heart versus his knowledge. Like, oh, what was in his what was in his mind? He wasn't acting maliciously. And do they ever do they keep these two roads separate or do they blur them so everything sounds like it needs to be bad faith, even though it doesn't? And on comparable evidence, how much work do they even do? Is it basically like a sentence about the daughter? Just count how often they talk about comparable evidence. And if they ever mention the defense's expert who said McCain's description of the footage is technically impossible. And I'd give you a spoiler alert, listen for the silence.
Spoiler alert.
Listen for the silence,
Yeah,
okay?
I don't find the daughter's potential testimony to be in any way comparable
No.
at all. I mean, like when you start taking into account all of the different factors from just eyewitness perspective alone to the fact that this is like a nightmare for this child to have to be going through. Plus, we don't know what she saw and she didn't see. You know, I mean, in the moments that led up to it. I mean, it's like it's just not comparable. It's just not. You know, I mean, I don't know if they being the state have spoken with the child. You know, I mean, how does the state know what she knows or what she'd testify to?
Right.
You know what I mean? It's like that's super presumptuous of the state, which doesn't surprise me. It's how they roll. The kings and queens of presumption. So, all right, the plan is to read this though, right?
Yeah, now we start reading. We're giving them a little bit of the background.
Okay, did you highlight one or can I just pull it up?
No, you can just pull it up.
Word. I love it. All right, cool.
I started to, and then I decided to research instead. So
Okay.
that's what you got.
I like that. I like that a lot. All right. So before we get started in earnest here, make sure you like, share, subscribe. We're closing in on 68,000 subs. And we'd like to hit that sooner rather than later. You guys can make that happen for us. So please remember to like, share, subscribe if you're replay after the fact, because I know this is 3 a.m. for our friends across the pond. Leave a comment. Helps it get out there into the ether. Also, we did set a goal. We're going to start grifting for our trip to Lonoke later this month. And the goal, if met tonight, will be that we will give our recap of a weekend with Runkle in the big city.
We're gonna do that on this live? Oh, if they meet the
at the end. If we
if
meet
they
the
meet the
goal.
goal. Oh, okay.
Remember, I'm real
Grifting.
strict about that. Yeah, I mean, well, yeah,
Okay.
I'm definitely grifting, but
Gotcha.
all right. Okay. All right. So let's get into the meat and potatoes of this thing. So this was filed today, June 1, and it is the state's response to defendant's motion to dismiss for due process violation or alternatively for spoliation instruction. So the state of Arkansas by and through Chief Deputy Prosecuting Attorney John Huggins for its response to the defense motion to dismiss for due process violation or alternatively for spoliation instruction states. Intro. The defense moves to dismiss this homicide case based upon the inadvertent, albeit negligent, loss of an SD card by Detective Robbie McCain with the Lonoke County Sheriff's Office, based upon the specious theory. Although no traditional bad faith motive exists, i.e., animus, shocking official misconduct.
I mean, I think they would have argued that was shocking official misconduct.
Agreed. Intentionally destroying evidence with a clear, sinister motive. By not following procedures, his actions rise to bad faith. Mere negligence by law enforcement, I think that's supposed to be an is, right? Is not following a procedure, or
No. Yeah.
in not following procedures does not rise to the level of bad faith. Courts have placed the burden on the defendant to establish a due process clause violation. The defendant has failed to meet its burden. So Detective Robbie McCain failed in several areas that led to the loss of the SD card. However, there is no proof provided by the defense that Detective McCain acted with any malice or intention to destroy evidence. So in the alternative, the defense requests a jury instruction commonly provided in civil cases that would permit the jury to assume the contents of a video that does not exist are favorable to the defendant. Allowing a remedy such as this would be wrong and inappropriate in that it shifts the burden to the defendant to prove the elements of either of the 2 spoliation tests set out in the Clark's case discussed below. So that's State v. Clark's. They cited it as a 2014 case. I think it's actually a 2024 case.
It's a typo. They did it throughout the entire thing.
Okay. So the finding of a due process violation is a matter of law.
So
the court to decide, not a jury.
So I just wanted to stop you there, and then I tried to stop you mid-sentence by accident.
Oopsies.
So I just want to point out what the state did in the first 90 seconds. So they're labeling the defense theory as specious, as Bob pointed out with his tone and reading.
Yes.
They conceded that McCain was negligent, and then they drew a line they want you to see, or they want the judge to see. Negligence on one side and sinister motive on the other, with nothing in between. And that's where the law lives, in the space between. A space they're pretending does not even exist. So, they slip in one of their arguments here about the due process question of law for a judge, and then the civil style jury instruction being inappropriate. That may be a fair point, but then they're literally, if you take that, it comes back against them, because it's only coming off to attack the instruction, not the request to dismiss or for a sanction. And then they're creating a new due process issue. Okay, so there's no alternative. The state's saying no alternative. So I guess if the judge agrees at all, he should just dismiss, because they're saying there's no other remedy here.
Okay. I like that. That was a real nice. All right. So in Brady v. Maryland, the Supreme Court held that the prosecution's suppression of material evidence favorable to the accused violates due process, whether the suppression is in good faith or bad faith. So a Brady violation requires one, the evidence at issue must be favorable to the accused, either because it's exculpatory or because it is impeaching. Two, the evidence must have been suppressed by the state either willfully or inadvertently. And three, the prejudice must have ensued. And that's from Brady v. Maryland, 1963. So, by contrast, the Supreme Court has distinguished suppression of existing evidence from a failure to preserve potentially useful evidence. In California v. Trombetta, the court held that the 14th Amendment does not impose a general duty on the state to preserve all potentially exculpatory evidence. And that's a 1984 U.S. Supreme Court case. The court found no due process violation arising from the failure to preserve, quote, breath samples, end quote, because the evidence was not destroyed in a calculated effort to circumvent disclosure obligations, but rather was pursuant to routine procedures disclosed and in good faith. So the court reaffirmed this principle in Arizona v. Youngblood, holding the state's failure to preserve semen samples, even if potentially useful to the defense, did not constitute a denial of due process absent a showing of bad faith by law enforcement. And that's Youngblood's a 1988 case. So the court explained that at most, the failure to preserve the evidence amounted to negligence where the evidence was not concealed from the defense and was made available for examination by the defendant and his experts. Thus, unless a defendant can demonstrate bad faith on the part of the police, the failure to preserve potentially useful evidence does not, in and of itself, violate due process. And then they go back to in State v. Clark's, the Arkansas Supreme Court provided two tests to determine whether a due process clause violation exists when law enforcement loses or destroys evidence. So in the first test, the burden is on the defendant to prove lost evidence was one, material, and had exculpatory value before the loss, and that two, the defendant is unable to obtain comparable evidence by reasonable means. So the second test requires the defendant to prove lost evidence, one, potentially useful in the defendant's case, and two, that the government acted in bad faith. Bad faith regarding lost or destroyed evidence is defined as intentional and performed with a sinister motive. Unintentional or negligent loss or destruction without a record of misconduct or animus is not bad faith. So Clark's further states that the bad faith requires more than innuendo and includes official misconduct that shocks the conscience of the court or an officer's actions where the primary purpose is to seek revocation or harass a defendant. The
So
state agreed.
let me
Yes,
jump in here because
please.
so here's what they did here. So they recited Brady, Trombetta, Youngblood, and Clark's, and then defined bad faith as intentional, sinister motive, amicus, shocks the conscience. But they didn't read the footnote in Youngblood, the very own footnote that says bad faith turns on police knowledge of the exculpatory value at the time it was lost or destroyed. It's let me read it directly from the thing here. Hold on, I have the case up. This footnote.
Appeals are made for walking. Just listen to Buried episode 12. Big win.
All right, so footnote.
Big win for
footnote
appeals are
one.
made for walking. Good
All
job.
right, so this is what footnote 1 says.
Yes.
It's weird because they have these two. They have like this preamble footnote, which I've never seen. So, all right. So I'm going to read both because it says so in the case, in this case, and that would be in Youngblood, the Arizona Court of Appeals relied on an earlier case holding that when identity is at issue, at trial and police permit destruction of evidence that could eliminate a defendant as a perpetrator, such loss is material to the defense and a denial of due process. Then they talk about some other reasoning, and when they departed from Trombetta, that Trombetta speaks to evidence whose exculpatory value is apparent. So that's the two lines we're talking about. You've got Trombetta that doesn't require bad faith, but it requires the exculpatory value be apparent. The possibility, and then they go on to say the possibility that the semen samples, that's what was at issue here, could have exculpated respondent if preserved or tested is not enough to satisfy the standard of constitutional materiality in Trombetta. Second, we made clear in Trombetta that the exculpatory value of evidence must be apparent, quote, before the evidence was destroyed. Here, and that would be in Youngblood again, the respondent has not shown the police knew that the samples would have exculpated him before it was destroyed. So that's something different than we have here. And they said the presence or absence of bad faith by the police for the purposes of due process must necessarily turn on the police's knowledge of the exculpatory value of the evidence at the time it was destroyed. And they're only focusing on like the malice part, and they're ignoring that in Trombetta, the court said like the primary thing that this turns on whether there was even bad faith or even whether bad faith is required is on the police's knowledge of the exculpatory value of the evidence at the time it was destroyed. So, and they completely just disregard that aspect of it. And the court goes on to say, talking about Napui, that the prosecution failed to inform the defense at the trial court that one of its witnesses had testified falsely. He had not promised favorable treatment. The court noted the conviction obtained by knowledge of the use of testimony must fail, and suggested that the conviction is invalid even where the perjured testimony is, quote, not the result of guile or desire to prejudice, for its impact was the same, preventing as it did a trial that could in any real sense be termed fair. Then they go on to cite to Giglio, where the court required the federal prosecutor to reveal a promise of non-prosecution if a witness testified, holding that whether the non-disclosure was a result of negligence or design it is the responsibility of the prosecutor. The good faith of the prosecutor thus was irrelevant for the purposes of due process. The court held that in some cases the government must disclose the defense identity of confidential informant, and there was no discussion or requirement of bad faith. So although not exactly on point, you can see how they're saying there's these times where bad faith is assumed based on the knowledge that the state has, and that don't need to show, it doesn't have to be sinister like this. The state here keeps trying to make everything. I don't know if I explained it well, babe.
Well, I mean, you were just reading. I don't know if you were explaining it at all.
Well, I was also explaining there at the end.
Oh, you were?
Well, I stopped reading the footnote and was talking there.
Oh.
Wow.
And it was fabulous.
Oh my gosh. Wow.
I'm not going to lie. My head had actually slipped to that fine piece of woodwork that Birdman made me that I promised him I would show on a live. I was thinking about that. I had drifted off into Birdman attended the meetup with Runkle on Saturday and brought Allie and I gifts. And I promised Birdman that I would show my gift on the live, which I love deeply, obviously, for reasons that you'll understand if and when we meet the goal and we get to discuss this weekend's fun and hijinks with the Runkle. All right.
I mean, but he also gave me delicious toffee, so
he did.
It was delightful.
It was
But so I just want to round this out by saying that, like, even Youngblood's own footnote says bad faith turns on the police's knowledge of the exculpatory value of the evidence at the time it was lost or destroyed. Knowledge, not this malice that they're focusing on.
So how do
And
we deal with the situation, babe, like McCain's, where he's claiming, even though it's clear he's not being truthful about what he saw on there, where he has testified that he saw nothing of value on there? You know, the problem for him is that he testified that they were all 15-minute videos,
here's
which are not possible on that particular model.
here's where
How
I
do we
think
deal with
they
that?
can reconcile that without just calling him a liar, is
Liar!
that, well, we can tell from what he testified to and what we know this camera does, he didn't see it all. He didn't access it right. There was file he was missing, a file he didn't look at. There's clearly something he didn't see because all of that stuff should have been there. And maybe they just say, he said he only looked at a couple like parts of it, or there were files he didn't open, and maybe he didn't download the full processor. I don't know. I feel like they can make some kind of frame it like that. You know what I mean?
Yeah, I
But
do I
but I
mean,
think
I think they did a good job already with doing that
mhm.
through the testimony of their expert.
And they kind of touched on it in the defense's brief. But so just remember as we keep reading it here that that the they the question is really whether the officer knew the exculpatory value. So that's the real test, is not whether McCain hated Spencer. It's whether McCain understood the dash cam to be what he understood it to be when slipped away and disappeared. And that kind of reframes the rest of the brief before we even read it. Every time the state says McCain had no sinister motive, the answer is wrong question. Like, count how often they engage with what he knew. The defense's brief is like wall to wall with it. He looked at it at the scene. He through the windshield. He interviewed the family and learned exactly what the night was all about. He knew it had two cameras and it likely had audio. So under the knowledge test, that's the ball game. And the state's silence on this is like the hole in the middle of the brief, as far as I see it.
Deafening. Their silence is deafening.
Yes.
All right. So the state agrees with the defense that the dash cam and the SD card possess potential exculpatory value and, in the same right, would have been potentially useful, although the state must emphasize that it also may have contained substantial incriminating evidence favorable to the state, including that Fosler was unarmed and shot 15 times, 5 of which were in his back. However, the defendant has not established that he is unable to obtain comparable evidence by reasonable means because the defendant's own daughter is an eyewitness
Wow.
and has testimonial evidence regarding the relevant events and will likely testify in favor of her father. Furthermore, Detective McCain did not destroy evidence. It was lost of no ill will. How do they know? They don't even know what fucking happened to it.
Right.
How are they sitting here saying, like, I mean, do they know something now? Now we know. Now we know how it was magically vanished. Like, this is how it happened, and it clearly wasn't malicious because this is how it happened. They don't know how it happened. They have no idea. There was only 2 cops who had hands on that thing before it got to the AG's office. So I don't know. Like, I don't know how they're making that argument. I really don't. Which again does not amount to bad faith. The defense is arguing that multiple mistakes amount to bad faith. However, equating sloppy police work to ill will and bad faith is mere innuendo. No evidence has been presented by the defense that Detective McCain's obviously negligent acts amounted to a due process violation.
All right. So here's just what I want to say about that. So in essence, they're kind of like admitting it had they're admitting it had potential exculpatory value, which is like, the first thing the defense has to show. And their hedge is only, well, maybe it was also incriminating, the 15 shots, all of that. But that under Trombetta, they're asking what was the value was apparent before the loss, not whether the footage was 100% helpful. The shot count is a jury argument about self-defense. It has nothing to do with whether any detective at that scene understood the recording mattered. And then again, they did this whole thing where, can Spencer rebuild this by comparable means? And the entire answer is, one sentence. Their daughter is an eyewitness. I mean, comparable evidence does not mean any other witness. Can you reconstruct what was lost? And an interested minor on the stand is not a substitute for neutral audio and video, because no matter which way her testimony goes, the argument the state would be making was like, well, yeah, we put her on, and she said this shit that helped her dad, assuming that's what it does. It's not neutral. She's the daughter of the defendant. She is the victim, whichever way you
She's
cut it.
both. She's both things.
And the law credits objective video over conflicting testimony every time. Every time. So the when you get to trial, not this petition, but trial or motion, the state has to disprove self-defense beyond a reasonable doubt, and they want to do it by putting on a frightened now teenager up against footage that they lost. I think they're trying to put Spencer on the stand as well, which maybe he's going to take it anyway. I mean, their logic only works if the accused testifies to recreate the footage, and he can't be forced to with his Fifth Amendment, Fifth Amendment right.
Yeah, no, I agree. But I they can't even make the argument as to Spencer, though, obviously. So that
right. But even with her, she's inside the truck. She can't testify to what the front-facing lens captured of the chase or the stop or the back one, Fosler's exit.
I think they're meaning that she can testify as to what she observed, which theoretically could be the same thing that the dash cam caught, right?
Well, not if she can't see from every angle.
Right. Or if she's laying down on the floorboard of the car. I mean, we just don't know any of those answers. I don't know where she was at in the cab. It's like we just don't know those answers yet in terms of what she would have been able to see or not see, depending on where she was located in that cab of that truck and what she was doing. It's like the bottom line is it's not comparable. Like her eyewitness testimony is not comparable. Like you said, it's like a camera gives two shits about sides, right? It's just recording what is in its field, and that's it. And it takes it in and it saves it, and then we can observe and argue about what it's showing. But in terms of what the camera is doing, it's the best evidence. There's no question about it, and it's not close. And I don't think her testimony is comparable at all. All right, you want to dig into the argument?
Yes. Should I just read from trying to see if I can see on your end? Okay. As a housekeeping matter, during the last pretrial hearing on April 30th, 2026, the court granted relief to the defense for the lost or destroyed SD memory card by providing two options. The first, to, quote, rest on the transcript, exhibits, and evidence, and they're italicizing this, already in the record and brief the issue. Now, Bob and I kind of pointed this out when we were reading the defense's brief, but let's read what they said. The second, an opportunity for another pretrial hearing to present evidence relevant to meeting its burden of proof as to either test of a due process violation. Here, not only has the defense been provided the opportunity to brief this issue, but has been able to supplement the record with more evidence without any safeguards of the rules of evidence and the requirement to put forth testimony, exhibits, and evidence through the proper channel, another pretrial hearing. The court permitted supplemental briefing, not supplementation of the evidentiary record. Any exhibits not introduced during the hearing are outside of the record and should not be considered, particularly the 911 calls, and they cite that as Defense Brief Exhibit 3, body cam footage from Deputy McCullough, who did not testify at the pretrial hearing, and that's Defense Brief Exhibits 5 and 7. The body cam footage from Deputy McCraney that was not introduced at any pretrial hearing, and that was their Exhibit 8, as well as the incident report containing hearsay, which was Defense Brief Exhibit 9. So, whatever exhibits and evidence, testimony or otherwise, that the defense has been able to improperly bootstrap into its brief should not be considered. This court should only allow what the defense chose as its remedy, a supplemental brief. So, um,
Yes.
I just didn't know if we should keep reading before we flesh this out more, or if we should.
Yeah, keep reading.
No, I think this next part goes into. So I mean, we kind of were worried about that. Was she putting in evidence that wasn't at the hearing? And if so, is the court going to consider it?
Yeah, I mean, wait, who's she? You
She
talking
is
about?
Aaron, the lawyer for the lawyers
Oh,
for the defense. Is it a he and a she? I don't know.
yeah, it's Aaron and Michael. So ask your question again.
Okay, so the state is saying they have bootstrapped this brief with new evidence that wasn't offered at the original hearing, and they had the two options. And you and I talked about this when we covered the defense's motion back in May. I was like looking, is it finally June? Um, where it seemed like there might be some stuff that they introduced as exhibits that were not offered at that hearing, and that's what the last two paragraphs just covered, is the state saying the court should not consider any of these exhibits, listing each one of them, that were not offered at the original hearing.
Well, I mean, so yeah, you're talking about the testimony, right, in McCullough?
No, like all that's I don't know what you were doing, but all the stuff we just listed, it was
It was the
um
it was the body cam footage from McCullough.
911 calls, body cam footage from McCullough, body cam footage from McCraney, and an incident report.
I don't see how any of that shit's relevant anyway,
Well,
because all that comes from after the fact, right? Body cam footage is going to be.
it could be the body cam footage of them telling him to turn off the the body cam footage. I mean, I don't know, you know? But
Yeah.
yeah, I mean, I guess the 911 calls don't particularly, um, so what I guess what you're saying here is that even if the state wins this argument, and because it does seem like that's a potential issue, that you're citing the stuff that wasn't introduced at that initial hearing, that it's like no harm, no foul, because none of it is that important unless one of it is him telling them to turn the body cam off of that. And definitely, the fact that there's
I mean, is
uh
there a dispute? I mean, they've admitted that they turned the body cam footage off or the
well, if there's
cameras
an
off.
incident report where they're still failing to say stuff, I mean, I don't know. I don't know. I mean,
Yeah.
that's the issue that they raised, and it's like, you know, it's possible that court's not going to consider stuff that wasn't, if the court agrees, we'll just say this: if the court agrees, then some of the defense's exhibits could get ruled, not to be considered in this ruling.
Yeah. I mean, to me, it matters not. It's all ex post facto in terms of like I don't think it's a big deal either way. I mean, if they introduce this shit, who cares? Like I mean, how in what world can it help? Like what could be captured on any of those body cam footage from the different deputies that could potentially help their cause? Like
You mean the
well,
defenses?
no, the states.
Well, but the whole point is the defense is trying to use stuff it didn't introduce at the original hearing, and that's what the state is saying no.
In terms of they're trying to say that the shit that they put in terms of their brief
Yeah.
wasn't stuff that was included. Like why? Well, I don't know how the judge ruled on this. In terms of when the judge says, "Okay, I want you to draft a memo of law," I'm going to give you two opportunities or two choices. I'm going to give you the opportunity to come in and we can hear this further beyond what Elmore heard. In which case, I'm sure he would have allowed the
It
defense to
it
put on whatever the fuck they wanted to put on. It just
exactly, and then he's quoting from the judge's ruling that the other option is, quote, "rest on the transcript, exhibits, and evidence already in the record."
Okay. Um,
So
yeah.
we'll just have to keep an eye out on that.
Yeah, I guess we will.
All right. So now
All right,
I'm
look at your
picking up on
phone,
page
man.
4, on
Look
page
at your
5, the top
look
of
at
page
your look
5.
at your
I'm
phone.
picking up at the
Okay.
top of page 5.
Okay.
I answered before you even. All right. In its April 30th, 2026 ruling, the court points to evidence in the record of irregularities, alleged mishandling of dash cam, and the failure to follow written policies regarding the crime scene. Detective McCain swore to facts in an affidavit and testified under oath before the court, subject to perjury regarding the dash cam and missing card. The defense argues that 6 alleged failures in totality amount to bad faith. Each alleged failure will be addressed in turn. First, McCain's alleged failure to photograph the position, location of the dash cam was not intentional. McCain testified that he did not see the dash cam initially. Oh, sorry, I don't have my things. Um, Silence. Now my brother's trying to get a hold of me. All sorts of stuff.
All right, just keep
Uh,
firing away.
okay, so you're trying to. All right. Um, First, McCain's alleged failure to photograph the position/location of the dash cam was not intentional. McCain testified he did not see the dash cam initially, but realized there was a dash cam in the truck right before the truck was ready to be towed. He described trying to, quote, get the dash cam out in time to get the truck moved and loaded to clear the highway back open, and that he was, quote, just trying to get it out of the truck and get it secured. Now, if you guys remember, he's claiming like he didn't actually see it with his eyes, even though he was able to take a picture of it because he's like, oh, I just stuck the camera in and started taking pictures without actually realizing it was there. That this is what the guy's claiming. And that has to be taken into account as far as I'm concerned. So he explained the positioning of the dash cam as being, quote, up in the top corners of the truck, and acknowledged it was an oversight on his part that, quote, it wasn't logged into the system and it got missed. Defendant's criticism of the order in which Detective McCain collected evidence relies on hindsight rather than the circumstances confronting him at the scene. The fact that defendant can now identify alternative investigative steps does not establish misconduct or bad faith. More importantly, the sequence in which Detective McCain collected evidence is irrelevant to the issue before the court. Detective McCain ultimately recovered the dash cam from the vehicle. While the defense argues Deputy McCraney alerted McCain to the possible dash cam early on, McCain testifies that he did not recall that interaction, which would be understandable and consistent with a typical chaotic crime scene. The subsequent loss of the SD card did not result from the order in which the evidence was collected. The defense offers no evidence connecting McCain's on-scene decisions to later loss of the evidence. All right, but what they do connect is his conduct being inconsistent with documenting and collecting the evidence. It's more consistent with concealing and waiting the last possible moment when no one's paying attention to grab something that might ultimately hurt the prosecution's case. And that's what they're saying, right? I mean, would you agree, babe?
Yes, I would. That's definitely what they're saying. That's 100% what they're saying.
I mean, it's kind of crazy.
But look, they have a cop who just inexplicably lost this shit. Like I mean, what else are they gonna say? You know what I mean? It's like we knew they were gonna come up with some bullshit, and this is the bullshit they came up with. At the end of the day, I mean, I guess we're gonna have to look at this and say, is there anything that we think that the judge might be able to hang his hat on as far as the state goes? And if if you're correct, and most of our attorney friends, including myself, but I think that there's probably a bigger window for this to get dismissed than maybe most, just because of everything else that's at play. But do you like when we get to the end of it, you're going to have to say, all right, well, look, I think this is a particular area where the judge is going to be able to say, okay, look, I agree with the state here. It's an extreme remedy to dismiss the cause of action, and I'm not willing to do it. So it's
Right.
going to trial, and I think I've got something in my eye and it's bugging the shit out of me. So keep reading. Are you reading your own? Are you reading your own version, or are you relying on my scrolling?
I was reading on mine, but you wanna at least scroll because 'cause I'm at the top of the next page, so if you scroll there, you can deal with
Okay.
your eye.
Yeah, I don't know. I got to put some drops in or some shit.
Alright. Second, McCain's failure to log the dash cam SD card in the evidence log may have been ill-advised or even negligent, but it does not satisfy either test set forth in State v. Clark. The failure to enter the dash cam SD card into evidence log does not establish bad faith. Detective McCain testified under oath that it was an oversight on his part that the dashboard cam, quote, got missed and wasn't logged in the system. He also testified that he kept the dash cam locked in a cabinet in his office before sending it to the Attorney General's office for testing. Although Detective McCain's handling of the evidence is negligent, showed poor judgment, or a failure to follow best practices, this does not equate an intentional act performed with ill will or sinister motive. Indeed, Detective McCain's actions in recovering the dash cam and retaining it for testing later are inconsistent with any claim that he intended to deprive the defendant of the evidence. No evidence has been presented to the defense proving otherwise. Accordingly, defendant has not established bad faith, and the alleged failure to log the dash cam and SD card does not amount to a due process violation. Now, here's the thing they're trying to do. They're trying to take each one separate, like, okay, now we're dealing with the second, and again, ignoring like the real world. Like, what's the guy supposed to say? He's supposed we've said it. You guys have said it in chat. Everyone says it. We all know it. They're not gonna just be like, oh yeah, oh yeah, you got me. Okay, I'm busted. Sorry. Oh, oops. And that he was intentionally trying to conceal it, and that he thought maybe it might hurt them, so he took it the last second and you know uh just didn't document it or anything. I mean, it's like the usual hindsight defense is you cannot blame an officer for not knowing something would matter later. But the defense's point is that it was obvious that night at the scene, with the scene glowing with the screen glowing in the windshield while everyone looked at it. You cannot call it hindsight when the significance of it was lit up on the dashboard in real time.
Yeah. So the way that I look at it is that, but for that email getting sent out in discovery, I don't think they were ever fessing it up. I mean, their only risk in terms of somebody bringing forth the fact that there was a dash cam in there was Aaron's daughter. Like, you know what I'm saying? I mean, if they're like, we're going to ghost this piece of evidence because for whatever reason, if it's exculpatory in nature, if he really did lose the SD card and he's like, fuck, what are we going to do? Like, we're just going to pretend like we didn't even recover it. We're going to act like it didn't exist. It's like we're good on the evidence log side of it. I never mentioned it in a report. It's not in any evidence log. There's no chain of custody. So for all intents and purposes, it's the fucking photo receipt from Gacy. It doesn't exist in the world
Right.
until it does. It's exactly
Right.
what's going on with it. And then by way of the defense becoming privy to that email, they're like, whoa, what dashboard cam? So then it changed the game for them. I mean, if I'm Aaron, I'm making the argument that they certainly weren't disclosing the fact that the thing existed up until we found out that it existed. Like there was no disclosure, and there's no question that that would be considered Brady material. You
Right, and then you look at, like, listen to their own, like, words. Their oversight is basically an admission of knowledge and not a denial of it. They're like, "It got missed. It was an oversight." You can only miss logging something you knew you had. Every oversight is a concession that McCain knew he was holding this camera and chose repeatedly not to put it on paper.
Anywhere, in any form.
One unlogged item is sloppy. The same item off the books by the same detective for a year is a fucking pattern. Sorry. And there's a case that the state did not cite, which I can't remember right now if the state did not cite, and I can't remember if the defense did. But in May of 2025, it was a State v. Russell. The Arkansas Supreme Court framed the question as whether the state showed the lost material had no exculpatory value, was available by other means, or was lost in good faith according to standard procedures. So that phrase matters. It's routine, by the book, loss is protected. McCain's solo, undocumented, off-book handling is the opposite of standard procedure. And this State v. Russell case shows that the state's, and it was like a year ago, drawing that line cuts against the state here. And we'll have to go back and look later if it's something that the defense already cited. If not, it's something they should cite in their response. But you cannot accidentally forget to log the one thing you personally hand carried for a year. That's not an oversight.
I mean, do they think that any judge that's worth a shit is going to buy that story? It's the most important piece of evidence in the entire case. And it's inexcusable that it didn't exist in any form or fashion in evidence as far as the Lonoke County Sheriff's Department is concerned at all. It was a thing that this guy had in his drawer, and that's it. Right. Who else may have known about it beyond McCain and whoever that, I forget what that person's name is that he hands it off to, who delivers it to the AG's office. I have to assume that other people in that department knew that thing existed. Right. If you're the judge, I'm hoping we see some heavy duty pushback, because the days of Ipsy Dixit and we're just trusting what the fucking cops are saying are dead and gone. We're over it. Cops are full of shit. They lie constantly. They're trained to lie.
It's getting I want to judges in every state in many ways. So your point's well taken. The time for that is past. I just want to see the
judge give it to him. I want to see the judge give it to him. I want to see pushback. I want to see a hot bench on it. If they're going to come with some bullshit, I want to see a hot bench on it. I want the judge to challenge him, because this we're just taking everything at face value that the state says in their briefs and what they testify to. Oh yeah, that's gospel bullshit.
You know where we saw a hot bench where a judge actually did that? In what's his name? Like the famous actor in the shooting at the scene.
Are you what are you talking about? Rust?
Yes. Where she's like, okay, no. It's too many coincidences here. And now the state's like lying, and she was like, I'm done with this. Fuck off, case dismissed.
Yeah. No doubt.
Yeah. So all right. So the state now addresses, now returning to the body of the state's response.
Wow.
And we're at the last paragraph on page 6. The state now addresses defense's third and fourth alleged failures. McCain's removal of the SD card and viewing of it before logging it into evidence was nothing more than normal investigative conduct that does not satisfy either test set forth in Clark's.
Oh yeah.
Oh really? Oh, it's totally normal. Oh, we look at it and then we don't write in a report about it. And he writes before logging it into evidence, like as though it was thereafter or shortly thereafter logged into evidence. What the, seriously?
It's crazy. Oh, we had a Cupcake Invasion, babe. I don't know if you're seeing it.
I'm not seeing it.
Hello, Cupcakes. We love you.
Cupcakes. Yes, we do. Mel. Yes, we are tearing apart and mocking the state's response to the defense motion to dismiss in Aaron Spencer case. So we're glad to have you guys.
Yes, we are.
Yeah. All right. So this McCain's handling of the SD card does not establish bad faith. Defense takes Detective McCain's testimony out of context regarding the removal and viewing of the SD card. Rather than viewing files on the dash cam itself, McCain removed the SD card and viewed the files on his computer in an effort to determine whether the card contained evidence of significance. McCain testified that he chose this method because he was unfamiliar with the controls of the dash cam and feared that one could, quote, hit a wrong button and you format the whole card. Thus, McCain's testimony reflects an effort to avoid destruction of data,
Oh,
not
what a guy. What
not
a guy.
an intent to destroy it.
Oh,
McCain was candid that, quote, this is the only dash cam that we've ever seized during an investigation, explaining his unfamiliarity with the device. He further testified regarding the files he observed on the SD card, and despite believing none of them appeared material, he nevertheless packaged the SD card and sent it to the Attorney General's office for further testing. These actions, but without the SD card. He further packaged it, and sent it for additional testing. But oops, I didn't send the SD card. So I don't know how this helps the state. Like, these are actions that are inconsistent with any claim that McCain acted with ill will, a sinister motive, or an intent to deprive the defendant of evidence. At most, defendant's criticism challenges the manner in which McCain conducted his investigation. However, disagreement with an investigator's methods, even if those methods could be characterized as imperfect, does not establish bad faith. Accordingly, defendant has not established a due process violation under either test articulated in Clark's. What now?
okay.
Like, are you living in a different reality?
Here's the deal. Okay. There's one thing in all my years that I know for a fact, that shit does not vanish into thin air. I've lived with 4 kids in this house. I've had shit go missing left and right. I'm scouring the house constantly for my shit. And the one thing that I know, and everybody denies it. Allie denies it. Scout denies it. Cameron, everybody's denying that they took my shit or they moved my shit. But one thing I know is that things don't vanish into thin air. Where did the SD card go? He packaged it up and went into one other cop's hands. Where did it go? They have to answer for it. They have to answer for it. He went so far as to say, I clicked it in. I stuck it back in. It clicked. I handed the whole package off to the other cop. Of course, it wasn't sealed. I just bent the little metal thingy down.
I forgot to lick it.
I didn't do the licking part. So, I mean, it's 2 cops have to answer for where the hell the SD card vanished to.
Right. And the state trying to be like, what do you mean? No bad faith. He actually sent it to the AG's office. No, though. He actually didn't send it because that's where
You
where
don't
it
just to
disappeared.
say that you sent some shit to the AG's office when you didn't. Because the fact is,
It
the
disappeared en
AG's
route.
office said, hey, bro, there's no SD card here. Oh, what? But no,
I
man,
sent it.
no,
I sent it.
I clicked it. I clicked it back in. I mean, this thing is,
I mean, there's like,
I have to assume the judge is going to be like, okay, everything that you're saying is ridiculous. Okay. So the question's going to remain. I'm going to find that on your watch, somehow this particular piece of evidence has vanished off the face of the earth. You're not giving me any kind of explanation, reasonable or otherwise, as to how that happened. So now I'm stuck with, what am I going to do with your case? Because that's what this thing boils down to. Does it have the weight for me as the judge that I think I'm about to stick a knife into the heart of your case and twist it, and it's dead and it's over because I'm dismissing it? I mean, I don't know. Like, to me, this is I can't think of a more egregious in recent memory, except for Delphi. Like, I mean, at Delphi, they lost all the interviews from the first 3 days of the the investigation, it's unbelievable. And it was the same shit. Like, oh, the flam shooter was flashing purple and, I pressed a button and then a Johnson rod popped out and then, all the shit got overwritten. Sorry. I mean, at what point are the courts going to say, no, you know what? Here's the deal. You've got important critical evidence, could be exculpatory, and you can't just lose it without there being a consequence to that happening. And to me, I just don't think. I mean, look, if they're stuck getting an instruction, it's better than nothing.
Right.
But
For
to
sure.
me, it's tantamount to like the most serious Brady violation that you can get. I
Right.
mean, they
And
they
I mean,
disappeared the evidence.
and then they're here arguing, all right, McCain pulls the SD card and views it on his own computer, and they're framing it as careful investigation. He feared formatting the card. Well, that's got two problems. The first is that explanation like literally eats itself. If he's so worried about destroying data on an unfamiliar device that he would not touch its buttons, meaning watching it in the view of the camera itself as opposed to taking it out and putting it in his computer, the safest move was to send it untouched to the fucking AG's lab, where every other piece of digital evidence in this case went. But instead, he opens it up alone, no documentation. So the fear of destroying it is the best argument against what he did. If you're afraid of doing something to it, why are you putting it into a foreign device? Why are you doing anything with it? Like you're so afraid that you don't want to touch the camera's buttons, but you're going to take it out and stick it into your computer. I don't know.
100%. Like any time that I'm disabling or pulling an external hard drive off and I get like a pop-up that's like, if you do this, something might happen. I'm like, I'm all right, I'm not fucking with it. It's like I don't know what I'm doing. I'm assuming that it was kind of the same thing in terms of him pulling that SD card out of the thing for all the reasons you were just saying. It would stand to reason that he wouldn't have messed with it at all if that's what his concern was,
Right,
right? I
exactly. That's what we're
Right,
saying. And then
right.
you've got problem 2, the state never even mentions the defense expert. And there is law out there that says like what the content on it doesn't really even matter. So what is it? Brandon Purchase, I think,
Yeah.
examined the camera. He testified that what McCain described seeing is technically impossible on this device. Not those file lengths, not that file structure, not the way the card supposedly even came loose. Like it clicks in. That's it. And then the state answers that with total silence.
Yeah.
Total silence. But then you've got this Eighth Circuit case. It's Jimerson, unless it's Yimerson, I don't know, but
Yemerson.
where the officer's characterization of the content is not the question. That's what the court said. In Jimerson, the state argued that a recording had no evidentiary value, and the Eighth Circuit said that doesn't matter because the concealment pattern is what shows bad faith, not the cops say so about what was on it. So the state is doing two losing things at once: building a case on an account of the defense. On an account that the defense's expert calls impossible, and resting on one argument that Jimerson says is beside the point, you know?
Well, and here's the thing. If McCain's description of the footage is physically impossible per Purchase's testimony at the hearing, then why is the state still standing on it? Why are they still standing on it? It's an impossibility. It's not a thing where, and the state did not dispute that in any way, shape, or form at the hearing. It went uncontested that whatever he testified to, and that he being McCain, was impossible because that particular model does not do it. It's not something that it's capable of doing. So, and even if you believe McCain that the footage showed nothing, Jimerson says that it's not. That is not the question. The question is why a man who saw nothing useful hid the card from every single written document and record for a year.
Over a
That's the
year.
question. Like, because again, we're never going to have the opportunity to kick down the doors of a police station when we believe that they're doing some nefarious shit and go be able to dig in their shit. Like, hey man, I'm gonna have to get in your computer, bro. I'm gonna have to get into all your files. I'm gonna have to peek around, man. Like, I'm gonna need all the footage from your internal cameras from the day of when you guys recovered this shit and what you've done. I need to get into McCain's computer specifically because I want to see if he actually put this in. That none of
Right.
that is ever happening for us as defense attorneys.
I feel like they could have done an
Man, I mean,
forensic, asked for some sort of forensic
what they
examination
could
of
have
that
done
computer.
is tried to ask for it. That's for
Right.
sure.
Yeah.
Whether, I mean, Elmore's clearly not granting it, but
I got a tickle.
the new judge might have been all about it. Might have been all about it. What do you mean you got a tickle in your throat?
I think my hair was like tickling my nose.
Ah, that's the cutest thing. So, yeah, I mean, look, at the end of the day, the state's whole, there's nothing exculpatory on it. That theme depends on a description that the camera cannot produce. And they've had 12 pages, and we've been through 7 of them, 6.5 thus far to deal with it. And you know what they've done? Not dealt with it at all. They're
Right.
pretending like that doesn't exist in the world as a
Yep.
thing, and it does. And look, all we can do in a situation like this is hope that the judge calls them on their bullshit. That's all you can
Alright.
hope.
So pick up on page 7. They're addressing the 5th and 6th alleged failures.
Okay. All right. So let's see. So the state now addresses. All right, hold on. I'm trying to blow this thing up here for me so I can see it good and proper. All right. Hold on. I've lost the plot. Oh, there it is. Okay. Okay. So the state now addresses the defense's 5th and 6th alleged failures. 5, the loss of the SD card, and 6, the failure to log the dash cam into the evidence system until October 16th of 2025. As previously discussed, under Clark's, the defendant may establish a due process violation in one of 2 ways. First, the defendant must prove the lost evidence was material. I think that's evident here, and possessed exculpatory value before its loss, and that comparable evidence is unavailable through reasonable means. So second, the defendant must prove that the evidence was potentially useful and that that law enforcement acted in bad faith. Defendant cannot satisfy either test. I think they can. So as to the 5th alleged failure, the loss of the SD card, I can't wait to read this. So the state acknowledges that the SD card may have contained material and exculpatory evidence, and it was certainly potentially useful evidence. However, the defendant cannot satisfy the first Clark's test because, as previously stated, comparable evidence remains available through the testimony of the defendant's daughter, so they're just repeating themselves.
Yep.
Right. So who was present during the events leading up to and during the shooting and can testify regarding those events. Thus, even assuming the SD card contained exculpatory information, the defendant cannot establish that comparable evidence is unavailable through reasonable means.
I think we've already torn that up, ripped it up, and kicked it across the room.
Yeah, that's just
shoved our foot right up the state's ass on that one.
That ain't it. Right? I mean, that the daughter ain't it.
She's not neutral, and she could not see everything that a camera can see. She's not a digital, her memory is not a digital recorder.
Exactly. I mean, no one is. No human being is. It's why eyewitness testimony is typically awful.
And again, that's what we were mentioning. She's like a teenager who is going through literally one of the most traumatic, if not the most traumatic event of her entire life. And how does that reflect on her ability to recall, remember, translate, process? Who knows if her eyes are open or closed at some points?
Oh my God. I mean, when you consider what she went through pre-Fosler arrest, the outcry, having to deal with everybody and all the feelings that kids that are groomed feel, which they shouldn't, but they do. And, going through therapy, her parents aren't knowing how to handle it, as it's a really tricky situation for parents, right? So, but then you fast forward 3 months and she's once again been
Taken and
attacked,
abused. Right.
like attacked that night.
That night.
And now it's just at the ass end of a high-speed chase that she knows her dad is behind, and they're pushed off the road. This guy's doing and saying whatever he's doing and saying
Who
in
knows if
that
you're
cab.
even, like, comprehending it at that point,
I mean,
registering all of it even.
that's my point.
Right?
Like,
No,
the
I'm
the
with you.
amount of shit that's going on in that moment of time and the minutes leading up to it is unbelievable for a 14-year-old kid. And, like, you wouldn't be able to really depend on anything that she's if you're the state, because you have to assume, like they say, well, we assume she's going to come on, testify favorably to her father. And they're going to use that down the road, to try to argue in closing. You can't trust her.
Or take this part she said, "That sounds right." But this other part she said, "That was just to help her dad." So
Right.
just take this part. And that's where the whole
It's it,
it's not neutral testimony.
it's
It's
not neutral and it's not comparable. It's
right.
just not. All right. So McCain testified that he removed the SD card from the dash cam because he was concerned that operating an unfamiliar device could result in the destruction of data. Explain it, because I'm not familiar with the device. Wait, am I reading new shit, or they just keep putting the same shit over and over in every paragraph? Because I'm not familiar. Like, you definitely read this, because I'm not on a different page.
Right. Yeah.
So because I'm not familiar with the device, hit a wrong button and you format the whole card. After viewing the files, McCain testified that the SD card was removed from the computer, placed back into the dash cam, and secured into place. He further testified that the dash cam was secured in an envelope and locked in his office pending forensic analysis, stating, quote, "The clasp was closed on the back of it, and then it was locked into my cabinet to be sent off for analysis." And they cite the transcript. So the dash cam was subsequently sent to the Attorney General's office on November 14th, 2024. Why are they completely eliminating the intermediary, the person that hand drove it out there? Where is that cop? Why are they why aren't they getting into how this thing was sent?
Right. Did it
Because,
tumble onto the floor? Did a dog eat it? Did did you shake it upside down?
I mean, all those things,
Was
because
it
it's one
really,
thing
really
like, oh,
bumpy
we
ride?
FedExed it, but we didn't put it in a FedEx envelope. And I just kept that little clasp thing down, and it must have slipped out. It popped out, slipped out of the envelope, and I don't know where it went. And it was the FedEx guy's fault. This isn't that. This is, he has it. He clicks it in, closes the envelope, puts the little hatch, the little clasp thing, hands it off, and then this person drives it to the AG's office. And somewhere in between, they're alleging that this thing just vanished into thin air. The math ain't mathing on it. So another similar case for the court to consider is, wow, you brought me a cracker? Scout brought me a club cracker, babe. Another similar case for the court to consider is Reed v. State, where relevant videos in a murder case were downloaded onto 3 discs. However, prior to trial, the lead investigator was terminated and the discs were misplaced and never found. The appellate court in Reed found no bad faith in this instance. Moreover, McCain testified that the dash cam was prioritized for review by the AG's office, except it wasn't prioritized in the sense that they didn't send it at the same time that they sent all of the other digital evidence. Right? So it was prioritized, or was it? Because everything else went, I think it was on the 10th. And that thing didn't go until I think the 14th.
Right. And this Reed case, did you finish reading the sentence of the paragraph about Reed?
Which one? I mean,
Just
I think so. I think so. What
because
were
I
you not? Which paragraph? I mean, I'm
the one you
reading.
just read, another similar case, this Reed case. I just wanted because I was looking at it.
Okay, so I don't think I've gotten to the next one yet. So I
No,
left
I'm
off.
gonna touch on Reed then.
Okay, let's go. Let's go.
So wait, now I took my screen off of it, of course. Where was I? Um Okay. So in Reed, and that's a 2024 case, the case reiterates the standard that to establish a due process violation when potentially useful evidence is destroyed, the defendant must show that they possessed exculpatory value evident before destruction. Again, that one's like they've even admitted it, and is of such a nature that comparable evidence could not be obtained by other reasonable means, which is what the state is basically laying their whole hat on, which is stupid. The court's treatment of the comparability element reinforces that the analysis requires consideration of whether the alternate evidence is genuinely equivalent in character and probative value to the lost evidence, not merely whether some other evidence touching on the same event exists. And the um wait, the the court further reiterated that
Yes.
so in
Yeah.
that case, right, because the case involved the defendant's claim of the state's failure to preserve video evidence combined with a pattern of lost evidence within the same department constituted a due process violation warranting a mistrial. But there, the court held that the due process violation for the destruction of potentially useful evidence that they must show the apparent exculpatory value beforehand. So, I mean, they reiterated that without a showing of bad faith, the failure to preserve potentially useful evidence doesn't constitute. But there they had this, they had this kind of difference that the Reed case supports a finding of no bad faith, where relevant videos in the murder case were misplaced and never found after the lead investigator was terminated. But that Reed case is distinguishable from this case, like in a critical way. The videos were downloaded onto 3 discs, and the discs were misplaced after the lead investigator was terminated, circumstances suggesting institutional disruption rather than like individual mishandling. Here, by contrast, the SD card was lost while in the sole personal custody of Detective McCain, who, as we all know, removed it and all of that. So the state's reliance on the fact that investigators prioritized and periodically inquired about the attorney general's examination doesn't address like the threshold failure. The SD card was already missing before it ever reached the SD card, the attorney general's office, because it wasn't in any evidence. And the failure to log it into evidence meant there was no official record of its existence to trigger any preservation obligation. Because Reed was more like, well, they should have preserved it and somehow got misplaced. And like overall, other instances where, the officer did something wrong. But this is in this very case, like multiple times that they completely and totally pretended that it didn't exist at all. And, and all those things. It's just, I think that Reed is just not comparable here. And it's going to bite against them at the end of the day because, you know, they, they never even say that it existed, you know?
Yeah. I mean, to me, it's distinguishable. It's simple. Like in the Reed case that they cite, it there's nobody watching that evidence, right? In this case, McCain is watching it the whole time. From the minute he takes it out of the truck, puts it in his drawer, takes it out of his drawer, takes the SD card out, puts it in the contraption, sticks it in his computer, allegedly watches the files, pulls the thing out, pulls the card out, puts it back in the thing. He's got his hand like the whole time. He's had it. But the problem is he never writes anything down that he has it in his possession. Like that's the problem. Like there's no, because I guarantee you, if we were to look at Reed and we were to say, hey, you know what? Let's look at the evidence log. When did you collect that piece of evidence? They're going to have it from the date they collected it, and you're going to be able to follow the chain of custody up until the time they lose it. The problem with this piece of evidence is it was never logged in any form or fashion, right?
Right. Right.
So, all right. I'm
I
about to go
mean,
back.
but
I'm about to go back.
again, there was no identified actor like in this Reed case. It was like the institutional issue that they weren't preserving evidence. And again, they relied on failures in other cases where that same police department in general failed to preserve, you know, evidence.
Yeah, I mean, there's no question. There's no
All right.
question. All
Am
right.
I picking up you
You
said, or
can.
you're continuing? No, no, no. I thought you said something. You're at moreover. Sorry.
Yeah, I'm at moreover.
Uh,
You know where I'm at? Moreover.
Moreover.
That's where I was. All right. So, moreover, McCain testified that the dash cam was prioritized for review by the Attorney General's office and that the investigators requested that it be looked at as soon as possible. He further testified that investigators made periodic inquiries regarding the process of the examination. Like in all those times that they're making periodic inquiries, they don't think to maybe now is when I create an evidence log. Should I
Right.
should I make this thing exist in the world in terms of papering it up for a potential case that we know is going to be happening because somebody's been arrested and this thing's going to go to trial and people are like I'm dying to
Babe,
hear.
I got a cop calling. So I'm gonna be on hold a sec.
Oh no! All right, okay, so I'll continue. So but that part of the whole equation for the state, I just hope that at some point, but I don't know that it's going to get argued. It's like we have brief and now we have response. I don't know if the defense is going to file a reply or not, or if this is going to be it and the judge is going to rule on paper. You know, we may never get that time unless there's another hearing closer to the trial wherein they're going to be able to have the judge like go at him. Like maybe the judge reads this and says, you know what? Here's where I'm at with it. Like I've got some questions that I need answered that were not addressed in the state's brief. So I'm going to have you all come in and we're going to take a little bit of time and we're going to go through some shit. And I'm going to ask some questions that I need answered before I can rule on this. Maybe that happens. I mean, it's certainly within the judge's discretion to do that. So I don't know how it's going to play out, but it's like this whole thing, this slippery slope, which is how it's always been, of law enforcement just being able to say, oops, sorry, we made a mistake. Oh, we overrode the data. Oh, we lost the SD card. Oh, we didn't realize that video existed. Oh, you know, we forgot to put it into evidence. Oh, we used red Solo cups to collect evidence. Oh, yeah, you know, we had a leaf blower to help kind of blow the snow away so we could see what's what. Like all the crazy shit. But in terms of losing evidence, like there has to be an end game wherein the courts have to start saying, here's the deal. It's near impossible for defense attorneys to prove bad faith. And if it's on its face potentially the most important piece of evidence that exists in the case, you're screwed. And I'm going to screw you on this case because the hope is, Mr. Officer, is that you're going to do better the next time. I mean, that's the whole point of the teeth in suppression motions and motions to dismiss. Yes, it is a drastic measure. It's the most drastic measure. But in a case like this, and I'm going to die on this hill, and I'm one of the few that's willing to die on it, the global set of circumstances surrounding this case is the perfect opportunity for the judge to make a statement here that this kind of police conduct will not stand any further in the state of Arkansas. I'm and if the state wants to try, and they would have the opportunity to appeal it. Whether they would or they won't, I don't know. I mean, I don't know what the Fosler family is feeling about Michael Fosler at this point, but I feel comfortable saying that a vast majority of people would be very, very happy if this case was dismissed. An overwhelming amount of people would be very happy if this case was dismissed. Like, the judge has all of these things in his favor in terms of dismissal. Turn it on its head. Put it in a case where everybody's not feeling some kind of way about the defendant and everybody's feeling a certain kind of way about the victim. And that's a hard case. That's a case where if you're a judge, you know that the public sentiment is not going to be behind you when you have to make a tough call because the law requires it in terms of suppressing a certain piece of evidence or what have you. But I mean, this is just not that case. It's kind of like the perfect storm to where I think that this is the case that the judge would be able to say, you know what, based on everything that I've been briefed on, this is where I'm at with it. And I think the law supports dismissal. It just makes the move. And I have no idea if the state, like Baldwin was talking about it during the fundraiser. Maybe the state's like, you know what? Thank you. Yeah, we're not gonna appeal that. We think the judge is right. We think that was a pretty big mistake, and we're gonna take it on the chin this time, and we'll do better. We'll do better moving forward. And then they close the book on the Aaron Spencer case, and everybody goes on with their lives trying to repair their lives. So we'll see. All right. So, moreover, I can't remember moreover, did I read that part already? Moreover, McCain testified the dash cam was prioritized for review. Yeah, we did. By Attorney General's office, and the investigators requested that it be looked at as soon as possible. That's when I went on a rant. He further testified that investigators made periodic inquiries regarding the progress of the examination. These actions are fundamentally inconsistent with an intent to suppress evidence or prevent its review. I disagree, Counselor, completely.
Yeah, me too.
I don't think it's fundamentally inconsistent with anything at all.
Because it didn't even make it to the age. But it didn't make it there.
Yeah, but it's not there.
He meant to send it, but it didn't.
It wasn't in evidence. In your world, it wasn't actually a piece of evidence yet.
It didn't exist.
It didn't exist on the planet.
So what did he try to send to who?
I don't know. All right, so likewise, McCain's conduct after learning the SD card was missing is inconsistent with bad faith, or is it? So McCain testified that he did not learn that the SD card was missing until he was contacted by Special Agent Calmer from the AG's office. When asked, what did he, after learning the SD card was missing, or asking what he did after learning the SD card was missing, McCain responded, I panicked. He further testified that he immediately notified Sergeant Lucas and Lieutenant.
Oh, now you're notifying people.
Oh, I gotta tell my boss.
Maybe I should notify some motherfuckers.
So listen, there was this dash cam.
Not on a report.
I didn't do any reports. There's no evidence log. It doesn't really exist on the planet.
But it's lost.
In terms of this case. But I lost like the thing that had all the videos on it somehow. I don't know what happened. So he further testified that he immediately notified Sergeant Lucas and Lieutenant Portale, and that they began tearing everything apart, trying to locate this thing. McCain later testified that he searched the locations where the SD card had been stored, viewed, or transported, including his office and Sergeant Lucas's county vehicle. There's good old Sergeant Lucas. That's who transported it. Finally pops in out of the hidey hole.
Did you handle the thing with care, Sergeant Lucas?
Finally, when asked whether he would like the SD card to be available, McCain responded, Oh, I would love for it to be here today.
Oh, well, that's it.
I mean, that's
guy-
not self-serving at all.
The guy he wishes it was
He
here.
wishes it was, of course.
I mean, all right. No, let's do better.
I find it decidedly inconvenient that they can't find the gun, as it would prove my innocence. Yeah, these are not the actions of an investigator attempting to destroy or conceal evidence. Rather, they are the actions of an investigator who believed evidence had been preserved and later discovered that it could not be located. So the same analysis applies to the defense's sixth alleged failure, the delayed logging of the dash cam. When asked why,
it was just delayed. It wasn't.
I mean,
it wasn't like not logged, and
I had a run of Wordles and connections in my New York Times puzzles for like 13 months. It was unbelievable. I couldn't do shit. There was no logging anything because I was extremely busy working on my New York Times puzzles. Have you seen the pips like the last 2 months? Yeah. All right.
Pips are
So
good. I like the pips.
Oh, you love pips. So when asked why the dash cam was not entered into evidence, McCain candidly admitted that the investigators were planning to send the electronics to the AG's office and that, quote, to be honest with you, it was an oversight on my part that it wasn't logged into the system and it got missed. Sorry. Mea culpa. My fault.
My bad.
We good? We good?
Sorry.
We good? That testimony directly refutes any suggestion that the failure to log the dash cam was intentional or motivated by ill will. Could you imagine if defendants were given this kind of leeway in terms of just believing everything they said because of the mere fact that they fucking said it? Wow. Well, you're right, sir. We are all we owe you a massive apology because you said so.
I didn't realize that. I mean,
Wow.
now that you say
He said it.
You really looked for it and it was just an oversight.
They tore the place apart. Yeah. Notably, no other evidence showing such an intent or motivation has been presented by the defendant. Yeah, I mean, great point.
Short of them turning off their body cams, not documenting it, not reporting it, watching it, and again, not reporting it.
Listen, we're going to turn off the body cams right now. You sure, Sarge? Listen, turn off the body cams.
Turn it off.
But that seems wrong, sir. Hey, listen. All right, so McCain further testified the dash cam remained in his office because investigators were planning to send the electronics to the AG's office for analysis. Heard that before. I mean,
and then when they did, I forgot to send it.
I forgot. Oh, it wasn't in there. Consistent with that testimony, the dash cam was, in fact, sent to the AG's office for forensics examination. Although McCain acknowledged that the dash cam should have been entered into evidence prior to going to the AG's office, an admitted oversight. He testified that the reasons the dash cam was not logged into evidence until October 16th of 2025, some 14 months later, was because, quote, that was when I received everything back from the AG's office.
All I need them to point out is one other piece of evidence that was also not logged like that and only logged in on October. I mean, if there's a couple other things, do you see all these other things that we didn't log because we were sending it to the AG's office and we waited for them all to come back and then log them?
All logged. They were
None.
all logged.
Right.
They were all logged before they were sent off. There is simply no evidence that McCain delayed logging the dash cam in order to conceal evidence, deprive the defendant of evidence, or gain a tactical advantage.
Wow.
Any argument that his collective mistakes, which are massive, were intentional is mere innuendo at best.
Wow.
Thank you,
I mean,
sir. Hold
this
on.
is
Got to drop the mic right there for him.
right.
Done.
This is the state's best storytelling.
Wow.
He sent it to the AG, asked them to hurry, panicked when it went missing, searched the cars, said he would love to have it. I mean, be fair, it sounds like a man who lost something, not one who hid it. I mean, that's their strongest argument there.
Yeah, that's consistent.
They think
Somebody
it's
just lost it.
I mean, that doesn't sound like a man who hid something. He was looking for it.
He tried to find it. All right, read the conclusion of prayer. Let's go.
All right.
Why the breath? Why the
Well,
big
because
breathing?
I thought we were going to discuss a little bit more before we went into the
Oh,
conclusion. But
such as what?
well, just like, if he truly believed he had preserved this evidence, like a man who truly believes he has preserved evidence does not leave it off every log for a year, skip every photograph, document not a single step, and have his superiors document nothing either. Like panic at the end does not erase a year of silence at the start. And the question again is what he knew and not how he felt when it vanished.
I felt bad. I felt really, really bad when I found out it was gone. You know what I mean? I felt
Right.
bad. I felt very, very bad. That's how I felt terrible. I felt like, did I do something wrong? Did I not click it into the dash cam proper? What happened to? I don't know. Where'd it go? And when I put it in the envelope, it was in there. Did you ask Lucas? Because I took the envelope and then I put it in Lucas's hands and then he took it away. Or she. I don't know. Did you talk to them?
Well, we
I
went
don't know.
out. We discussed Jimerson. It's Jimerson v. Payne, and that's an Arkansas
Boring.
case.
I'm
Well, the court found bad faith from there, a 4-part pattern: personal review of the recording,
kidding.
deliberate omission from official documents,
Mhm.
uninformative response to the defense, and concealment of the recording's existence.
Mhm.
It's like it's
On all fours. It sounds like it's on all fours.
right. And
We
they
have
were like
personal review of the recording, check. Deliberate omission from official documents, check. Uninformative responses to the defense, check. And then the concealment of the recording device or its existence, check. Again, defense doesn't know anything about it until such time that they run into an email between the AG and McCain saying, hey, that SD card you keep asking me about, we don't got it. That's it. I mean, that's in the law, that's what they call on all fours, right?
And those deliberate omissions, those are indicative of bad faith, period. And that's something the state just does not address. That there is law that says those kind of deliberate omissions are indicative of bad faith, not just an innuendo.
Well,
not just
babe, you know as well as I do, if you have something that you cannot address, either with case law or argument, this is what you get. This thing. How do they address it? Pretend you're the prosecutor. How would you try to address this when you have the fact pattern that we know that exists in the world for this?
I mean, I
Can
guess
you think of a better way to
no.
like, oh, look over here? It's it's that classic diversion shit. Squirrel, look over there.
Right, and then
kind of argue the law the wrong way and hope that the judge isn't real smart and maybe that'll work.
right, and they're like relying on this Reed case, which again, that was like a situation where no one was minding the store when the one investigator got left, and they were like, oops, we don't know where the shit that, where everything went. But in the Spencer case, you have that's one man doing it all alone. And he's got, he just got it off books on purpose.
Yeah.
But
Yeah.
there was also some Ninth Circuit case, which it's not their circuit, but the Zaragoza Moreria,
Oh, yeah.
whatever, the
That
Ninth
one.
Circuit case where they found bad faith because the agent's own interview proved he understood the value before it disappeared, which McCain's interviewing the family. And we know this from the other pleadings where the daughter is saying he was watching the footage, the camera, because he wanted to see who's coming up from behind him.
Well, beyond that, the state's already conceding in its own motion here in the beginning that it's highly likely that there was exculpatory evidence. I mean, they conceded that in here. Right? Am I crazy? Like in the beginning of it, don't they say, where's that? Where is that? Well, we concede that there could have been some. Oh, yeah. Where is it? I gotta find it. You know what I'm talking about? Like, are you acting like you don't remember?
No, I thought it was somewhere in the middle where they
said it a couple of times.
Yeah.
All right. Boop, boop. Boop, boop.
Search for words too.
I'm not doing that. Okay, so the state agrees with the defense that the dash cam and the SD card possessed potential exculpatory value. Okay, and in the same right would have been potentially useful. Distinguish that from the case that you just read.
No, nothing. I got
No, I
nothing.
mean, can you distinguish it?
I don't think so. No.
I mean,
I'd have to look a
can't
little
argue out
further.
of both
Maybe I
sides of your
could.
mouth. I mean, right, on some bullshit.
Yeah, but and that's exactly what they're doing. It's like this is the most important evidence, but the daughter can testify the same thing, so don't worry about it.
Right. I don't think we
Because he
need to
looked.
belabor the point anymore.
No.
So,
All right, conclusion and prayer for relief. The
Thank
common thread running through each of the defendant's allegations is that Detective McCain made mistakes in handling the dash cam and the SD card. I don't think so. I think you're way understating the defense's position.
understatement.
Of the year. McCain himself acknowledged as much. However, the issue before the court is not whether McCain followed best practices in every respect, nor is the issue whether, with the benefit of hindsight, different procedures could have been employed. The issue under Clark's is whether the evidence demonstrates an intentional act performed with ill will or a sinister motive. It does not. Indeed, nearly every challenged action identified by the defendant is inconsistent with a finding of bad faith. McCain removed the dash cam from the vehicle because he recognized that its evidentiary value and wanted to secure it. He removed the SD card because he was concerned that attempting to operate an unfamiliar device could result in its loss of data, so he did it anyway and put it in an inconsistent device. Okay. He viewed the files to determine whether they contained relevant evidence and then failed to document it. He reinserted the SD card into the dash cam and ensured it was secured so then it couldn't have accidentally fallen out and someone must have removed it. I mean, I can keep going with every single point they make. So, all right, he stored the dash cam pending forensic examination and ultimately sent it to the Attorney General's office for analysis, although it arrived without the thing that needed to be analyzed. When he learned the SD card was missing, he testified that he panicked.
Oh, no.
Immediately notified his supervisors and participated in every effort to locate it, except for the place where he hid it. These are not the actions of an investigator attempting to suppress evidence. Rather, they are the actions of an investigator attempting to preserve and analyze evidence who later discovered that mistakes had occurred in the handling of that evidence. At most, the record supports a finding of negligence, oversight.
In our house, let me interrupt you real quick. If I were to plug me into the McCain role here, in our house, what my wife would say to me in that particular situation is, Bob, you fucked it. That's what she'd say to me. That would be her judicial ruling on the entire matter. as panicked as I might be, babe, I've done this thing. She would say, honey, I
You
only
fucked
have
it.
a few words for you. And it's, Bob, you fucked it. And that's what it would be. That would be the rule. That would be the ruling of the MOTTA court. And I'd be sentenced to whatever she'd sentenced me to. There'd be no walking it back. It would be a terrible, terrible.
Do you remember that I looked for it though?
I really checked the whole house.
But if you never mentioned to any of us that it existed, so why did you do
didn't
that?
even know, like you wouldn't have known unless you saw it on the credit card bill that I bought this thing 12 months ago to be upset that I've lost it. You didn't know. How can you miss something that you didn't know existed, babe?
All right.
Let's go.
Under Clark's, however, negligence is not bad faith. Again, misciting to Clark's. Because defendant has failed to establish either the absence of comparable evidence or the existence of bad faith, no due process violation occurred. Furthermore, defendant asks for an extreme remedy and dismissal. Rarely do courts use their inherent authority to outright dismiss cases as a remedy for spoliation. No cite there. Dismissal is generally reserved for egregious misconduct, such as that we see here. Dismissal should be the outlier and only used in cases that shock the conscience of the court, citing to Clark's with the wrong citation. Though the state does not concede that any remedy is required, should the court find that any remedy is necessary for the alleged spoliation, a jury instruction would be more appropriate. It is important to note that Arkansas appellate courts have not yet permitted a spoliation jury instruction, a civil construct, in a criminal case, even when considering law enforcement's failure to preserve an inadvertent deletion of body camera footage, finding that it did not amount to destruction in bad faith, citing Long. I mean, of course, when the cops delete body cam footage, it's inadvertent. The finger slipped. I hit delete instead of store. I mean, this is the kind of things that courts have been believing for the existence of time. So no, I am not surprised the state is making this argument here. And as much as I want a judge who's going to bitch slap the state and the state's agents, the officers and detectives, when they pull this shit, somehow every court, except that Rust judge, says, oh, he just said it was an accident. So, it was an accident. Whatever.
Oopsies.
Wherefore, for the foregoing reasons, the defendant has failed to meet his burden of proof to prove bad faith as required, and the state respectfully requests the defendant's request for dismissal or, in the alternative, an adverse inference jury instruction for alleged spoliation be denied.
Here's what I hope the judge's order reads. State, you fucked it.
You fucked it.
Case dismissed. And that would be classic. We're all here for it. That would be my favorite read, my favorite legal document read of all time. Just like 6 words. State, you fucked it. Case dismissed.
I mean,
that's it.
It's like their entire thing is just McCain made a mistake, but is not a villain. And it's
all right. So here, Judge Erskine was lurking, watching, and she said, Judge Mary Marlowe Summer in the Baldwin case said it best. Dismissal with prejudice is warranted to ensure the integrity of the judicial system and the efficient administration of justice. There is no way for the court to right this wrong. This is the case here. And that's what this is the judge, back to the judge. So that was a quote. And then Judge Erskine says, this is the case here. And that's what the judge here should be saying. The failures are too egregious. Thank you, Judge Erskine. I feel vindicated.
We'll feel more vindicated if this judge does anything remotely like that.
Yes.
I really hope he does.
Far more class than us. So she would never write, State, you have fucked it. Casey Smith, as much as she might want to.
I already feel bad for all my foul language since she's
So
watching.
many swear words. She knows we're foul mouthed. She loves that about us. We say the things that she thinks, but she maintains decorum at all times.
Yes. So, yeah. Under a typical scenario with a typical judge, yes, dismissal is a long shot. I agree with Judge Erskine that if there's a case where it needs to get done, this is it.
And your husband, you mean?
Yes, I was just saying that. And as Bob has said numerous times, he's kind of hoping like the backdrop of this case and including all the political stuff, but whatever, that the judge's sensibility is like, this should have never been here. So I'm going to use this opportunity to say goodbye.
Yep.
And then,
what a gift that would be to this family that's gone through so much. Just because the stress of a trial, there's just nothing like it. For anybody involved, for the lawyers, for the defendant, for the Spencer family, for the daughter, who might have to do the unthinkable and get up on that stand and relive portions of this nightmare. No one wants this case to go to trial, except for me. Like, I guess the Fosler family might, maybe. I'd have a hard time backing my old man at this point, but that's just me.
right.
I'd be like, man, my dad apparently was a super creep.
I took off whatever you had highlighted. Did you?
Oh, it was Birdman saying, I did not make that gift. I acquired it in the mid-90s from a friend.
In the mid-90s?
I can't take credit for such a masterpiece. All right, I'm going to go get that.
In the mid-90s?
He's had it for a minute.
Wait. Oh, the gift he gave you. I'm like, wait a minute.
Yeah. Oh,
I could not have been eating food from the 90s.
Coffee from the mid-90s.
Thanks a lot, Birdman.
Well, thanks, Birdman, for the old coffee. It was delicious. All right, well, I'm going to go get that thing.
All right. While he's doing that, I will welcome two people we know very well. D Nice to me and Shiboogies are new members or returning members. I know Shiboogies has been a member. And I'm pretty sure D Nice has too, but we love you both. Stitched and solved. How is the state not responsible for this egregious loss? So glad y'all are covering this. I'm baffled this is even a trial. Yes, we all agree. So does Judge Erskine. And thanks for your generosity. But yeah, all of the things you said. DZNY or Disney, maybe Disney Babe. Hi, Bob. Sorry you couldn't be there at Meetup Alley. Maybe we'll meet next time. Thanks for the Spencer coverage. Yes, maybe we will meet next time. I was helping get ready for our granddaughter's 2nd birthday, and it was a smashing success, mostly because of all the work I did. So Birdman 1980 gifted 5 Defense Diary podcast memberships. Well, thank you, Birdman.
Wow, you could not hear me cackling when you said that because I had my mic muted, but
yeah,
it was quite a guffaw, I'll tell you. Okay.
Dr. Vonda K, thank you for your generosity. Did the people meet the whatever it's called?
Huh?
The
expand on that thought. I don't know what you're talking about.
When you set a goal, did they meet the goal? Perimenopause brain moment.
I don't know. Let me see. What was
and don't forget, we got Kim. Might as well just thank her now.
I mean, sure.
Our everyday angel.
Our everyday angel.
Appeals are made for walking. I'm obsessed with you lovebirds. You two are precious people. Oh, well, thank you. And we appreciate your generosity.
No, we're short. 14 on 20. Well,
people better keep going.
I have to include the Venmos.
Yeah, you count those.
I'll count those.
Rhonda Brinsfield. So glad y'all will be there with the Spencers during the trial. Yes, we will. We will. And thanks for your generosity. Angela, thanks for your generosity. It was so great meeting everyone. Missed Allie so much. Thank you. Becky, the bestie, got me to my car and I loved everyone. Well, that's good. Someone had got her safely to her car. I need some Allie in my life. I'm
I mean,
close
it was a
enough.
big drive. It was a big drive.
Bears game at ASAP. Thanks to Bob, Runkle, Kurt, and everyone.
Oh, yeah.
I mean, boys were talking about how great it was. So you guys made it pretty special. Gray Space, and Gray Space was there too, right? Member for 6
Yes.
months.
That was
Great meeting
delightful.
you, Bab, even if Allie wasn't there. Oh, sorry, Gray
Yeah,
Space.
I got to spend some quality time with Gray, which was awesome. Brilliant.
Under
Brilliant
your
human being.
scars. I don't get it. It was viewed and set aside for a year and not recording. That's okay. MFers. I mean,
Indeed.
I agree. I agree.
Exactly.
Thanks for your
Exactly.
generosity. Shannon, let's fucking go.
Oh, yeah.
Thanks
Oh,
for
let's
your
go.
generosity. Ain't so plain Jane, goal. All right, people are contributing to the goal.
Indeed.
Julia Miller just got home from CrimeCon, so getting here late, but I'm glad you guys will be boots on the ground there.
I'm not gonna lie, Julia. I think that the meetup that happened in a nice little Irish tavern in the city of Chicago was better than CrimeCon. I'm gonna guess that it was.
Better than the whole of CrimeCon.
The whole
There you
thing.
go.
The whole
The
thing.
whole thing. Thanks for your generosity.
Thank you.
And
Thank you.
Nancy knew, does the F card have C-spam on it? I mean, the SD card had nothing on it, just lights flashing in the trees. All of the things it's designed to record, it didn't
Yeah,
record.
Nancy knew. In case it came from the dashboard cam that was in Fosler's truck.
So yes, we're talking about what would have recorded the scene, and starting with, you know, Aaron Spencer chasing and trying to get the car to stop. And then what happens when this guy Fosler jumps out of the car aggressively with something in hand coming towards Aaron that prompted Aaron to shoot. That's what's missing, is all that footage. And thanks for your generosity.
Yes.
Russ Titsworth. I wonder if that's Russ's real name.
If that
Russ
really is your name,
Titsworth.
sir, Mr. Titsworth.
When did they turn the cam off and crack pipe on vid? Oh yeah, like how does where was the crack pipe on any video? The alleged crack pipe?
I mean, they eventually admitted that that was a whole bunch of hullabaloo,
Bullshit.
that it was in there before Aaron got in there, and
Yeah.
wasn't
And that
hidden.
was in the cop's car that transported him. So I don't know if they turned that camera off or not. They turned off their body cameras. But thanks for your generosity, Russ. Dawn says, gotta jump off early, but we'll catch the rest on replay. Good luck with the goal. Well,
Aw.
hi on replay, Dawn.
Thanks, Dawn.
Thanks, Dawn. Oh, for fuck's sake. Any cam I've ever had, it's usually attached to an app that also has a cloud. My dash cam videos have always gone to the cloud as well as an SD card.
Oh, for fuck's sake. Nailed it.
Yeah.
Did we look in the cloud?
I mean, I would hope that this expert purchase guy would be like, hey, there's this secondary place it could have gone.
There's this
So-
thing called a cloud. I don't know what it is. It's not a real
But he may have
cloud.
had his set not to do that because he's recording a bunch of perverted criminal shit of what he's doing to kids in that vehicle. So,
Indeed.
I don't know. Lucifer says, an antidote regarding itchy doggos. We tried everything, including allergy shots, and no luck. Finally switched to natural balance vegan diet, and the relief was nearly instantaneous. I just
Wow.
switched him to new food that's supposed to help.
Is it
What did I
vegan?
do? No, I got
You went from like a real hoity-toity brand to like a classic dog food. Like, what is that shit called?
it's Purina. But
Something.
it was like I looked at the ingredients. It's like it doesn't have the other fillers. You know, we always wanted not grain free, but not like the fillers that just did nothing. And the first ingredient was not meal, it was actual protein. Well, salmon. I don't know. It's the Purina Pro plan for sensitive skin, large dogs. but I guess we'll have to keep looking. I mean, what we are actually going to do is switch back to that expensive allergy medicine because that did work. The doctor kind of thought if we got him under control and then switched to Benadryl, it would maintain, but he's itching again. So,
He's itching.
but thank you, Lucifer.
Yes.
And there's Birdman, which we addressed. Thanks again, Birdman. Lindsay
Caw.
Bay,
Caw.
dismissal. Let's go.
Let's go.
Nay, member for 22 months.
Love it.
Awesome work, Bob and Allie. Thank you for your continued support. OG.
Yes, Nay. Love you.
Yeah. Lori Jane, member for 4 months. Thanks for your continued support. I'll see you at the trial if not dismissed. All right.
All right. Love it.
Weird Debbie, member for 14 months. Thanks for covering this family hug. What'd she get, babe?
Aw, family hug.
Thanks.
I give
Weird
out a
Debbie.
lot of in-person family hugs.
Mandy Reardon, totally off topic. Please, can you tell me what your intro music is? It's cool as shit.
It's original. You're never going to find it. Darren, our producer, made it. So he took a really, really old sample from an old blues song, and the whole underlay, like the beat and everything else, is all Darren. Original. I told him to put it on Spotify because you're not the first, and you won't be the last to enjoy our intro music. We love it. We love it.
Yeah.
Like on
we
the
used to have
rare
it so
occasion, somebody's like, "Your intro music's no good." I'm like, "Go blow it out your ass, man."
What do you have on Venmo or PayPal?
On Venmo, as you said, our daily angel Kim sent us 25.
Thanks,
Good
Kim.
evening, she says. Thank you both.
Thank
And
you.
then Lucky Rabbit 1912 sent us 5 solid on Venmo towards the goal. Love you both, and I refuse to let YouTube take part of your grift. I mean tip. Laugh with tears, shit-eating grin, and winky face emojis. Thank you so much.
Thank you.
And that's gospel. I mean, we love
That
Venmo
is.
the most because they didn't, the tubes.
But
doesn't
it's
get
the
cut.
ease by which people can do this that
100%.
at least they can do it. Right.
It's easier. And then Jenny paid us an extraordinary $50 for all that you do. Double hearts. Thank you, Jenny, so much. And then Maria, she paid us 5 fake super chat, avoiding YouTube fees. Smiley face. Thank you all for that.
All right, so we have reached the goal with those other people, especially that generous $50. So
yeah.
Is there anything else? Because we don't want to leave anyone out. If anyone on some other app.
Let me see if there was a Cash App or a PayPal. I don't know.
And then what we're gonna do, I guess, is talk about the Runkle invasion, which was also the Kurt invasion.
Yes, it was 2 invasions for the price of 1. No, we didn't get one today, but I feel like I should give love to Premier Paralegal. Threw a 20 at it and said, "For your diligent efforts for the wrongfully convicted." Wow, that's a good one. That was a Cash Apper on Friday. So thank you for that. We really, really appreciate that.
Person's like, those people never said anything to me.
Well, I think they
watches again.
I think they sent that when we were out on our Runkle day. It was Friday. So when we did our
that's right. We didn't go live. Okay.
Right. Well, we did go live, but I couldn't see when people were seeing
yeah.
now. So
yeah.
Better late than never. Wait, I'll check PayPal, but I think there's only like 6 people on the plan that still use PayPal. Nothing. All right. Okay. So yeah, Runkle lands Thursday. I go scoop him from the airport. I knew he was going to be exhausted. It was a long, long travel day. He left his house at the crack of dawn to get to the airport, and long flight, connector, all that shit. He lands in Chicago around 5 o'clock. We're stuck in rush hour traffic. I immediately tell him, we're going to Johnny's. I got to get you the Italian beef. I bring him, get him the beef. He loves it. I think he talked about it on his live tonight on his Chicago recap. Delicious sandwich. The thing is unparalleled. It's the finest sandwich in the land, bar none. We come home. Runkle needs rest. All those that love Runks know he needs to sleep. and he has a real hard time sleeping because of various back issues and other things. So
Let's not tell his
he
personal
talks about that
information.
all the time. Like that's not something like he tells, all his people. Like, so Runkle fights with sleep pretty heavily. So Runkle Saturday, we decide, tells me I got to get a Chicago hot dog. I'm like, done. I got the spot. So we go get the pile in the car, me, Allie, and Runkle. Runkle says, hey, Kurt's flying in. We arranged to meet Kurt at some point because he's getting in a little later on the day. And so we head down to the city. We hit Weiner Circle, get a couple of Chicago dogs.
What a
Now,
name.
the charm of the Weiner Circle is that they give
Not a
you all
circle of
kinds of shit.
wieners.
Right. No, it's not a circle. It's not a circle jerk, even though Allie thinks it sounds like it, which, I'm like, honey, that's like a play on a winner's circle, right?
That's not where my
yeah.
mind went.
Oh, yeah. Oh, clearly, that's not where mine went. It went to the dirty place. So we end up going there. We get a fabulous Chicago hot dog. Runkle loves it so much he gets two. But the charm of it, and you can go to their Instagram. The main gal that works behind the counter just talks mad shit, and it's awesome in the best way.
Wait, at the Weiner Circle?
Yes, it's like it's
on a phone call. I missed all that.
yeah, it's the equivalent to what used to be Ed DeBevick's, the old
Right.
50s diner, where part of the reason he went in was to catch shit from the waiters and the waitresses.
And
Same
thanks, Ann
concept.
Piccolo. We appreciate you.
We always. So we do the dogs. After we do the dogs, we then make our way to the escape room, and Runkle and Allie and myself all go in. We dominate it. It was a wizard theme. It was the wizard trials, and I think it was like kid friendly. It definitely did not have any scary elements to it, but it was a fun room, quality room.
It wasn't 8 out of 10 hard.
Yeah, the difficulty level was very high, and it was
Yeah.
only 3 of us, and it was an 8 cap room.
And he said,
so
I think he said less than 50%
yeah,
get out
the
when
ex- the
they've got
escape
all
rate
those
was low.
people.
Yeah, so we
Yeah.
did well. We did well. We worked well as a team. We crushed that. So
Did
we get
work
out
well.
of there after we dominate that room, and at that point, we hit a spot, kind of like the near west side, up like around Logan Park. We hit a place called Federales. We have some cocktails. That's where we actually went live for a little bit over there.
Well, we
We'd
had some
gone live
cocktails. You
prior
had some
to- yeah.
alcohol-free cocktails.
Yeah, I don't, like everybody knows I don't drink, but all my people, they imbibed. Allie got a price, like a nice little buzz on pretty quick. Per usual.
Per usual.
She goes in hot. She
Lightweight.
fades out very quickly. It's like goes in, starts pounding, and then she's drunk for 20 minutes to an hour, and then she's not. And then she's got a hangover and she doesn't feel good. And like, I think I'm dying. Why did I drink? And all that shit.
Come on, now you're making it a little excessive there.
So while we're there, Kurt, is adamant that we have to, and Ian skipped this in his recap completely, that we went
That's how
to
good it was.
right. That we went to Second City for their evening show. But before we did that, we hit Pequod's and we got it to go. So like Allie was like, oh, I want to try to get us a table at Pequod's. She's, on the reservation system. There's nothing until 10:30. She called. She's like, can we do like a walk-in? Like, is that a thing that we could do? He's like, yeah, you can walk in. She's like, well, how long will it take? He's like, 10:30. You can walk in, and then we'll see you at 10:30.
If you walk in now, you're getting the next available time.
Right. So the Second City was starting at 9:30. We're like, all right, this is what we're gonna do. We're gonna order the thing to go. We'll go over there, pick it up, and then we'll eat it like in a park.
We had car pizza because we never made it to the park. We were supposed to eat it at a park.
Yeah, well, we ended up eating it in the parking garage. So
Right.
it still had park in it.
Yes.
It just wasn't a park. It was a parking garage. So, I cut it all up. I opened the tailgate, cut the thing up, served everybody. We eat the pizza. Disappointed. I hadn't had Pequod's in a very, very long time. The crust was not crisp at the bottom, which it's supposed to be. It's supposed to be flaky and delicious. When I heated it up in the oven, babe, It was as it was intended. So
Yeah.
I think they undercooked it by about 5 minutes, and that's why we got kind of the doughy, soft crust. It's not how it's supposed to be.
Yeah.
I felt vindicated because I wanted to bring him to Uno's,
Right.
which is better than Lou Malnati's. It's better than Gino's East. It just is. It's like I'm not going to argue about it. It just is, and it's better than Pequod's. I've never gotten a pizza of that quality.
That's the first time I ever ate at Pequod's, and I was
I mean, the sauce was delicious.
underwhelmed.
Well, I mean, imagine if the crust would have been right. Like the sauce was on point.
Yeah.
There's no question. You
At
know,
Second City, we would have just preferred maybe Kurt got up on stage and started doing some
maybe
what's it called?
improv.
Improv.
Yeah. I would have really been throwing some shit at him. So we get over there and we had gotten our tickets, and the way that the seating works, if you're a GA, because all the premium shit was gone. And Allie's like, I'm gonna slip the hostess like a little tippy poo. So she goes
I was
in.
like, who's got a 20? No one did. So technically
Kurt did. Kurt had a 20.
Right. Kurt gave the tip.
He plied you with the cash, and then Allie put it in the hand. Super, super conspicuous. Like here. It wasn't like
there were like 3 different people involved. I'm like,
quick handshake.
Who is deciding where we sit? And the woman says, I am. So I said, here, this is
for you to help.
So what was I supposed to say? Okay, she was like behind a thingy. There, I know how to do a slick shake off, handoff. I mean,
the old slick shake off handoff.
Shake off handoff.
That it wasn't the shake off handoff that you were hoping to, but it was very effective because she ended up putting us in like the second row, like center stage. We got fabulous seats
Fabulous
seats. And then, the show was underwhelming, but I kept telling these guys, I'm like, 2 times ago that I was there, I walked out of Second City feeling the exact same way that I felt when we walked out this time, underwhelmed. I'm like, wasn't that funny? Like, it was okay.
And who were they, babe? Who were they?
But I said the exact words. I said, I don't think anybody from this cast is going to make it Saturday Night Live, because if you don't know, Second City and SCTV up in Canada, like those are the feeders for Saturday Night Live. That's where they get their talent. When you look at the incredible people that have come through Second City, Chicago, it's unbelievable. The amount of people that have gone on to great success, starting with Saturday Night Live and then movie career. It's unbelievable. Like, Google it. It's amazing. It's an amazing cast of actors and actresses that have gone through that place. So that time when I walked out, the very next year, I flip on Saturday Night Live, and 2 of the cast members from that very review were on there, and it was Tim Meadows, who I still never thought that was that funny, but Chris Farley, who obviously had a fabulous career,
right, and
successful on both Saturday Night Live, and it was like a lot of physical comedy. Kurt took exception to some of the kind of the ways that they were operating in there. I was just underwhelmed. I think, like you said, it spoke volumes that Ian didn't even include it into the recap that he did over on his channel. So but it was still fun. It was a great day. We had a great day in the city. We had perfect weather. It was beautiful out. No rain. It wasn't oppressively hot. Ian got to see a little bit of the city. We got to hit his food spots that he wanted to hit. He's a foodie like me, so he loves food, and he always wants to try regional cuisine that is, something that's known for in that particular city. So I think we hit all those. And then Saturday, Allie had to prep for the baby party. So me, Kurt, and Ian. Well, actually, Kurt left. I brought him to the train. He hopped on the train. He did the
museum, the art museum.
Yeah, he went to the Chicago Art Museum, spent a few hours there. Then he hooked up with us, and then we went in. And by the time we got in at 5:30, which was a half an hour before it started, we already had people in there. So, and like these folks had brought like a ton of baked goods, a bunch of like pre-mixed drinks that were quite delicious.
Drinks were a big hit. What the boys didn't drink, we took to the party, and everybody loved it.
Yeah.
So
for sure. They really enjoyed it.
And there was some lemon pound cake that was quite delightful.
Oh yeah. The old lemon pound cake. My father was very excited about the lemon pound cake.
Yeah.
He said, "Bob, where's that lemon pound cake?" I said, "It's over there, man." I'm like, "You want a piece of that?" And he's like, "Oh, oh yeah. Oh yeah. Oh boy." Yeah. So, the meetup was phenomenal. Like Runkle had like reserved this room at the Green Door Tavern, and it was like the back room. It was long, kind of skinny, but we had an amazing crowd. It was packed to the gills in there. I'm sure that we hit the $1,500 spend in like the first hour. So like time flies in those events. Runkle was saying, and he's like, I feel like there were so many people that I couldn't get to everybody. You always kind of feel like that, because it's like you want to be able to engage in meaningful conversation with people instead of just, how I am, babe. Like any kind of thing that we do that. I always want to have meaningful conversations with people because that's why they're coming, right? So, I get why Runkle's like, yeah, maybe next time we'll do a smaller one with like smaller amount of people, just so everybody gets quality time, which I think is important. But I think everybody had a wonderful time. I think people that were nervous because they have a little bit of social anxiety. And I'm like, man, forget all that. Like, you're going to be with friends. Everybody's like-minded here. We're all going to be talking about the
And we're
shit we
just that
love.
simple to solve social anxiety
I
with us.
mean, it's like,
Don't
but
worry
like
about it. You're loved.
everybody that came, I was right. They had a great time. Like the discomfort melted away. It's like I bring people in, I give the family hugs, and it's all okay. It's okay.
So Shannon says, I love that pic of Runkle in the wild. He needs a giant poster of that. I don't know if it screams. It's supposed to read Sam Squatch. I don't know that.
From a great Canadian show, Trailer Park Boys. That's where I pimped that right from Bubs. He always called a Sasquatch a Sam Squatch.
Right.
So, but Allie worked very, very hard because I had the vision. I
don't know if it
I wanted Runkle in the classic
Bigfoot sighting pose.
right, Bigfoot walking pose. So that's the picture that I took of Runkle from in front of Johnny's. And Allie did all the work, and she made an amazing thumbnail from that thing. I love it. She also made a couple. I don't know if you have them. Like, can you?
You want to see the failed attempts? Like,
well, yeah,
as we were.
Start with go through the process because it's worth looking at.
Oh, the very first one.
Yeah, look at the first.
Oh boy,
one, and then get to where they start getting good.
Oh god, I wish you could click the share this screen instead from this, but you can't. I have to keep going out and back in.
So that's a Bigfoot body there. So that was the first one. That was the first one.
That was the first one.
That was a massive fail. That was a fail. So we're like, no, we're not going to use that one. We're just not going to use it.
I don't even know what the hell this one was. I told him to make it more in a walking pose, like maybe coming behind two buildings, like he's poking out, make it look more like, classic Bigfoot sighting. And this is what we got.
Oh, yeah. Oh, it's terrible.
Where'd it go?
It's horrible.
Wait, it's not. I don't know.
It's not up yet.
I don't know what happened. Oh, I have to click open with preview. Okay.
I always wonder, is that criminality? I love that song too. That has to be, is that an original? If it is, that thing's an awesome song.
That's what's next. That's
Runkle there he is, kind of floating.
Yep, that's just Ian of the Bailey, loose in the loop.
Runkle of the Bailey. All right, so start getting to the good ones. Get to the couple of like one. I was torn. Do I use the one with Runkle with his human form, or do I use the one where, the next one you're going to show? I'm assuming.
Well, so this one was where we were like, wait a minute, maybe I'm going to be able to do it like this, where I'll just be able to to switch through screens. Hold on. That was next.
Oh yes. See, he's got the Sam Squanch body. So he's gigantic in that one, right?
Right. I was like, it's not supposed to be
He's not King
a
Kong.
King
Yeah,
Kong.
right. He's not King Kong.
Can you see this one, or do I have to make it smaller?
Well, can you just scroll it up a little bit? Oh yeah.
Wasn't
Make it a
letting
little
me.
bigger. See, that's a great one. Like that one kind of matches Runkle's head hair. Like that was a good one. Like that was the one I was gonna go with, I think, right?
Yeah, but I was trying to get it to not make it just look like he was casually walking, to still make it like
I mean,
movement and,
it's still
you
kind
know.
of the Bigfoot thing. You know what I mean? So
So then when I told it to do that, it ended up doing this shit. And now I'm like, no, he's jogging. Why is it that he's just jogging?
Runkle's jogging.
All right. Then we had this one. This is the good one that
This is the good one.
you were contemplating using. There we go.
Oh yeah. He's still
And
jogging.
then I told him, like, make the fingers outstretched, like he's still jogging.
And he's not running. Like that guy's in a full sprint. That guy is sprinting.
But I was like, make the fingers go out.
Yeah. Yeah, it was wild.
But then it did this. So
where?
this one won't open. And the fingers were still not out. So I don't know what the hell was going on.
Yeah.
Nah, fuck it. I'm not gonna put that one up. It's too stupid.
So is that all of them?
Yeah.
All right. Okay. So here, get us big. So we got a few gifts. And like, so Birdman brought me this, which I now know is circa mid-90s. And the best way to describe it, if you remember that cartoon on Saturday Night Live that they did with the ambiguously gay duo, that they were always in that pose when they were on the thing. So that's what this is. So what you've got is you've got a Chicago bear.
No, you're gonna get. Runkle told you.
What?
You're gonna get.
No. I hid the other thing. Like the only thing that's gonna get me is your mouth.
Oh,
you can't see anything. So here, so you got a little Packer. See a Packer there?
oh,
Packers player with the football.
So crude.
It's very crude. Hide your children's eyeballs, because that's how Birdman rolls. So, and then there's this thing I can do, and then the bear does this. Can you see that? So,
okay.
They
see it. They see it.
So that was I love this thing personally. Birdman called it. He said it's sports related.
Scout was like, "What is this thing? What is it? What is happening?"
So it was a bear
on
top of a Packers player.
Yeah.
Doing the deed.
Oh, now you just described it to YouTube.
Oh, okay. Oh. I thought it was fabulous. All right. So, yeah, look, for those of you that made it to the live, I was able to hand out a bunch of stickers, babe. So that was fabulous, because everybody knows my horrible aversion to the post office. So it was wonderful to be able to hand out stickers to all of those that were interested in getting stickers. So I gave out a lot of stickers. That was so much fun. And like the part of the thing that none of us planned, which we made the best of, was that Ian had not locked down the space for the entire night at 9 o'clock. As it turned out, we were getting booted from the bar, from our secret lair back there. So I'm like, all right, I got to go try to find on the run here. I'm going to find another spot. I find this headquarters, like a pennycade, like a beercade. So where they have I thought it was going to be
file a lawsuit against.
Well, yeah, because we walk and there's all like 30, 40 of us. So it's a huge pack of us go over there, and we have one person that's in a chair, and so we need ADA compliant spots. We need a ramp or an elevator, something to get our ADA friend up there. And so I open the door, and it's like a steep set of stairs up to like a second floor where all the shit is. And I go up there after we had sent a bunch of people in, and I'm like, yo, like, where's the ramp? He's like, well, he looked up, and this is the bouncer. He's like, what? I'm like, the ramp. I'm like, we have one of our friends is in a wheelchair. He's like, oh, I don't think we have one. I'm like, really? I'm like, what about an elevator? He's like, nah, man, I don't. So I go back down, I give the bad news. We're like, all right, we're rolling. So we found another place outdoor. It was getting chilly, but we hung out there for a while. I was obsessed with trying to find us a place indoor somewhere because I was, of course, underdressed and it was very cold.
He was cold.
I was very cold. It was very, very cold. So I find another place, again, outdoor, but I could tell there was a potential for us to be able to get there. Plus, they carved out space for us. We were going to get service outside because the second place that we found, they weren't going to be willing to serve us outside. So we had a waitress that came. But the third place was closing at midnight, which in retrospect, I mean, we had a long drive back, worked out perfectly for everybody. I hope. And I know a lot of people came from long distances. We had folks from Michigan that drove. We had folks from West Virginia that drove. From all
the Carolinas.
Indiana. Yeah, I mean, Ange was
People that
there.
took
She drove in from Indiana.
flights.
Yeah, there were flights had, drives made. It was a fabulous turnout, and everybody was lovely in real life,
So
just like
thanks to all of you who
chat.
helped us just get to this goal. Thanks to all of you who made the event a memorable one.
Indeed. Oh, and then we did get one last.
And Piccolo.
Wait, there were a couple more. So Mary had sent. I think it was supposed to be $10. It was $9.71. Love you guys. Keep on it. Free Spencer. Thank you, Mary. And then Anne, our delightful Ann Piccolo, she sent $5. She said, "Did you discuss the Mullis decision at all?" No. Sleuthy just let me know that he was not getting relief. So Todd Mullis, the hearing that I abandoned about midway through, which everyone was pretty confident that was the corn rake killer, where he's claiming that his wife stepped on a corn rake and it impaled her in the back. So we did like half of it and then I dipped on it. So apparently that just came down. I'm not aware, and Sleuthy's not aware of any kind of written order as of yet. So they just came out and said, no deal. So that's disappointing. Based on what I saw, I thought they had a pretty strong case over there. So, what are you going to do? So thank you for that, Anne. And she said, I was having dinner with the fam and I missed that part. So no, we didn't hit it. I found out about it late. So that's it. I think both Allie and I are of the mindset that this state's response was a big steaming pile of horse shit. Yeah. So that's our legal determination of the horse shit. All right, you guys, we love you so very, very much. You guys are just fabulous human beings. Mods, we love you. If you are so inclined, our mods have a tip jar. You could buy them a pizza. All of it gets split.
Go to Uno's though, not Pequot's.
Yeah, do that. So make sure that you're taking care of our mods. They keep our chat the best in the land. It's just unparalleled. They keep it safe. They do all the work.
Here it is. Oh no, that's Defense Diaries.
No, the girls will put it up. I saw Sharon threw it up. So but I think the mod's been on cock-a-doodle, not working good. Yeah, I don't even know anything about the Chow case. What's that all about? I don't even know. You guys will have to tell me. Chow. All right, so mods, thank you so much. Remember to tip those guys because they deserve it. And we love you, mods. Thank you for all your hard work. The bot's not working. Yeah, I kept seeing that. I saw that it wasn't working. How weird. It's on strike. The robots are striking. I knew it was going to happen. And then to you guys who we love so very much, new and old alike, we adore you. Thank you for your constant support. Thank you for watching our show. Thank you for choosing to spend your time with Allie and I. It means the world to both of us. We love it so much. And we love you as well. So remember, if you're replay, like, share, and subscribe. Leave a comment. If you were here before you leave, and hype. Yes, hype it up. And if you're here, just shrink that chat down, hit that like button, and subscribe for God's sake. It's free. Those are all free
Yes.
things.
Yes, please.
Free,
Please.
free. All right, you guys, we love you. And I just want you to remember this very, very important thing. Okay. Without y'all, I'm just an old